Hey everybody, this is Josh Schachnow, Canadian immigration lawyer and CEO at Visto.ai for another episode of the Canadian Immigration Pros podcast. This will be an interesting one with my guest, Daniel Escott. Daniel, first of all, thank you very much for coming on the show today.
Thank you very much for having me. I was looking forward to this.
And one of the reasons why this is very interesting is because Daniel is not, I'm going to let you give a quick introduction here in just a second, but not your traditional, maybe not yet,
Well,
practicing lawyer or immigration professional, right? We'll be doing a lot of talk about AI, about research, about planning, about court systems and stuff like that. So I'm very interested. Before we do jump in, can you give everybody a little bit of an introduction, a little bit about who you are and your background?
I can certainly try. My claim to fame these days is that I've started as a research fellow with the Artificial Intelligence Risk and Regulation Lab, where I'm housing a lot of my current research on the use of artificial intelligence in high risk scenarios. Before that, I clerked at the federal court. And while at the federal court, I took the lead on artificial intelligence policy, both for lawyers and for the court itself. And I've since become an external member of the federal court's AI working group.
All right. That's a great, hopefully sets a great stage for what will be a likely heavily AI focused conversation, naturally speaking. So, Daniel, let's talk first. I want to talk about the court because selfishly, at Vista, we provide AI and different tools and automation to law firms. And so I try to stay apprised of what is happening in the industry and requirements and stuff like that. Can you give everyone a quick overview of what came out of the federal court? I think it was this earlier this year, right? In terms of instructions and the paper on the proper use of AI related to the Federal Court of Canada.
Sure. So there's two different documents. There's the federal court's notice to the profession and public on the use of artificial intelligence in proceedings at the court. This is, for most practicing lawyers, going to be the meat and potatoes that they've probably seen at some other courts in smaller versions. The federal court's main requirement, there's a series of principles that basically boil down to don't be an idiot when you're using AI. Please make sure that your client is informed. You're thinking about things like cybersecurity. You're not trusting legal advice from ChatGPT, this kind of stuff. But specifically, when you're using a generative AI that produces text or other content that ends up in a document, a final draft of a document that gets submitted to the court, something like an affidavit or an exhibit, a legal memo, you need to disclose that generative AI was used, how it was used, and which parts of that document are generated, whether or not you've gone through and edited them. And the reason for that is not to put lawyers under any kind of focus or heat. What we're trying to get at is there's not a great level of technical competence in the bar. This is true of not just the immigration bar, the legal profession broadly. And when you start talking about things like large language models, generative AI, automated decision-making tools, you kind of see the eyes glaze over a bit. And we know the risks. Don't copy and paste stuff out of ChatGPT, that kind of stuff. But that's not it. The bigger concern is that things get missed. And it's not like we're trying to name and shame certain law firms that have made this kind of style of operating a more normal part of their day-to-day operations. It's that when something like a large language model hallucinates, it pulls something out of thin air. If it's a case name or a citation or a weird quote, it's easy to fix. But when that stuff starts finding its way into an affidavit, into an exhibit that you're submitting to the court or that someone's going to be examined on, when you're looking at what makes it into the final decision by the court, you start getting into some more fundamental questions of, for the sake of safeguarding not just the actual administration of justice, but the public trust in the institution of the court, what should we be alive to today? And it may not be the same requirements 3 years down the road, but right now, people know that generative AI in various contexts is being used by lawyers, and we're just trying to help those people trust the process. The
Right.
second,
Can we put a pause there before we get to the second one? Because what I'd love, I just want to dive a little bit deeper. Number one, can you clarify what are the types of immigration files that this really applies to, right? Because I don't want some people that might be listening and maybe they're, newer to the Canadian immigration realm, shall we say, like this specifically applies to the federal court. So
yes.
if you're submitting a visitor visa application to IRCC, that this has no relation, right? Could you maybe for a second talk about where, which types of applications might this actually apply? And secondly, do you like one of my thoughts from this is that this might actually just dissuade lawyers from using AI to begin with because they're afraid that if I have to disclose this, what is the judge going to think? Right. So I'd love to hear your opinion on both of those.
They're separate but very interesting questions. The first, obviously, the federal court policies only apply to the federal court, but the way the scope was worded was so specific. It only applies to uses of generative AI that produce content that are included in a document that was prepared for the purpose of litigation and is submitted to the court for a proceeding before the court.
Got it.
So if a self-rep that uses ChatGPT to write their personal statement that they're going to send in with their study permit application to IRCC, it might tick every other box, but it was not prepared for the purpose of litigation. And so that's out of scope. I know IRCC, and when it comes to the refugee side, that the IRB and the tribunals are all looking at their own different versions of requirements based on the federal court because we set pretty high bar. But as of yet, I don't believe there's any requirements quite as onerous as this for the processing side of the immigration world. This is just litigation.
Got it. Got it. So this would probably apply mostly to things like judicial reviews and kind of stuff along those lines.
That's exactly it.
Got it. Okay. And so what would you say to the statement of or maybe the concern of like, as you said, the bar is, shall we say, not at the forefront of innovation to begin with. And now, is it not a concern to have this disclosure as compared to not having to have the disclosure?
So I think there's two sides to this, and I understand the concern. When the notice was first put out by the court, the first iteration came out in December of last year. It was updated in May of this year. The initial version got a lot of pushback about this chilling effect on innovation in the legal profession, whatever that may look like. And I think it has to be underscored that even those in the profession who are relatively up to date on, what is AI, what are the different types of AI, the long-term impact of not just generative AI, but AI-based and related tools over the next few years. It's been said so many times that it has the capacity to change the practice of law. I think it already has, because when we're looking at, especially the immigration bar, the transition from the billable hour to block fees, especially for something like a processing application or even a lot of judicial reviews now, no longer about getting as much out of a file as you can. You bill $5,000 or whatever you quoted, and that's it, whether you spend 1 hour on it or 3. So your time is valuable. At a certain point, I think where we're going to see this profession go is it might become a malpractice issue or an insurance issue if you aren't using these tools. Because
Hmm.
if your client is going through some litigation with the federal court and you're using all the brand new tools, they have incredible benefits to your quality of service, your quality of legal research. And my client with an almost identical file has to deal with me going through everything by hand, trying to come up with, 15 hours of research uncannily, all this back and forth. at a certain point, you're going to be hurting your client if you're not keeping up with this kind of stuff. So it's in my opinion, a necessary evil in the interim, whether or not it may be evil, to require that these kinds of uses are disclosed, if only to get visibility on the issue. But the other side of this is I don't actually know if the chilling effect is real. I think the legal profession had, if you go back and look at the studies in the late 80s, early 90s, when computers were rolled out, PCs took the industry by storm and everyone figured, well, this is the end of the legal profession as we know it. It was a huge pushback. Despite the obvious benefits, the utility and the value to your client of being able to do this in a modern way, it didn't actually change anything. It made a lot of specific and discrete tasks a lot easier, but the fundamental nature of being a lawyer doesn't change. It's
Mhm.
it's not so much this, well, we have to disclose it, and so we're disincentivized to use it. I think it's a little more that inherent resistance to change that comes from not knowing a lot of these tools.
I mean, I would push back on that a little bit because when people started adopting the computer, they didn't have to disclose to IRCC that, hey, I used a computer to submit, to prepare this application, right?
Mm,
And my fear is that if I don't do litigation files, I've never done a JR, in my life, but I've heard it from the mouths of lawyers who say, do I want the judge to have this disclosure show up, right? Like, I don't think it's far-fetched to say that, like, right now, right? Because as you said, this came out in December and was revised in May, and I'll just date for those listening after the fact. We're recording this on November 14th. This episode will probably be live in about a week or a few days from now. So we're talking in November 2024. Do you not think there's already lawyers right now saying, you know what? Yes, AI is great. I use it for some of these other things. But I'm a little concerned for my client that if, the the feds submit their submissions with no AI and I
mm.
submit my submission and I do disclose the use of AI, what is the judge thinking, right? And maybe turning this bit of a rant into an actual question, because you had insight from the inside, like what do the judges or what is happening behind the scenes? Obviously, there you can't tell me everything, but
Mm.
what happens or what do you think happens if a judge receives a submission and there is that disclosure? And I know that like the first half of that answer has to be, oh, nothing, it doesn't affect anything. But like, is there any way we can go deeper and talk a little bit about, well, you know what, like this is how they might actually think about it, et cetera, et cetera.
Well, I'll call it the correct answer, and then there's the deeper, more philosophical answer. So the biggest piece of feedback that we got when we initially published the December notice was concern about, is this going to bias the judge? Are they going to go through my facts with a fine-tooth comb here? Are they going to nitpick? And that was not the intention, but there was a huge amount of concern there. So in the May update, we actually included a new principle in the notice called the neutrality of the court. And the court made a commitment in the update that there will be no adverse inference from including this declaration. And the whole purpose of it is just visibility. It's no different than any kind of disclaimer or risk notice where we're trying something new. We want you to know about it because things can happen that you wouldn't normally expect to happen. Like if a lawyer were to include something in an affidavit, like an exhibit, or I can even pull a real world example from Washington State, where a video was, or I think it was the Department of Justice tried to admit a video into evidence that had been enhanced using artificial intelligence. And the court refused to admit it, not because it was enhanced by an AI, but because there was no explanation as to what was done to enhance or change that video.
Mm-hmm.
If you don't have these kinds of declarations, at least until we're at a point where asking these questions becomes commonplace, you're not going to question, I submit a video to you, you're not going to question the authenticity of that video. My Photoshop skills are not that great. But if I say this video has been enhanced using artificial intelligence, then you're going to say, okay, well, I need you to explain what was done here.
Right.
And it's such a simple change in frame to say, in 90% of cases, it's not an issue. But it's
Mm-hmm.
that 10% of cases where if that judge didn't ask that question and they relied on it, and the person in that video wasn't actually the convicted person or the accused, what happens? People are going to come crying out to DOJ saying, oh, well, this is a poor practice for law enforcement. They're going to come after the court, and their faith in the institution will be rattled. And it only
Right.
takes one.
Right.
But I think,
Yeah, I mean, I guess part of where I'm coming from is I think it's like more nuanced. Like again, I think what you're saying makes total sense. If you're enhancing video, pictures, et cetera, it totally makes sense how that should be disclosed and further explained. But if we take it at its core, drafting language, let's say, right? Writing down words, right?
yep,
If you have an articling student and it's their second day on the job and they draft the first version of your affidavit and you're in a rush and you don't review it, or maybe you review it really fast and you miss a few of their mistakes and you submit it to the court, like how is that any different from having to disclose, hey, an articling student prepared this? Or even better, hey, a clerk, a 19, not to make age like really that important here, but like, hey, a 19-year-old clerk prepared the first version of this, right? So I fail to see too much of a difference between things like that. And my fear is that their disclosure requirement, while I do see what you're saying in terms of adding some value on the transparency side, I think it's going to deter a lot more. I think the damage in deterrence is not personally, this is a personal opinion. The damage that we're going to see in terms of deterrence is going to outweigh the benefit of just effectively having like a light bulb just say, hey, AI was used here.
and
Any thoughts on that?
honestly, I completely agree. The nuance is that, and this is where my philosophical response comes in.
This is the good
I
stuff.
think that's the point. Having that moment of pause of, do I want to use this generative AI tool I know absolutely nothing about and have no training or education in to write legal documents that I have to take liability for, essentially, if I screw up, or if it screws up and I'm not keen enough to catch it? You shouldn't be using it. If you were to hand something off to an articling student and the product they give you, you don't have the capacity or expertise to fact check, you shouldn't have that articling student writing stuff. And that's where the conversation needs to go. The big concern and why such a big push was made to institute this policy is that the legal profession, when ChatGPT 4 came out, jumped on wholesale. This is a great $20 solution. I don't have to do any drafting anymore. You can't do that. If I were to come to your office and pitch that you can fire every associate and articling student you have as long as you never question any work product I ever give you, you'd look at me like I had 7 heads. It's the exact same value proposition. If you don't have the capacity, the education, the training to trust yourself in fact checking something that a generative AI produced, you probably shouldn't be using it to produce legal documents for your clients. The ones that I've spoken to, the lawyers that I've spoken to who don't have an issue with this declaration requirement are the ones who live this day in, day out. They know this. They know the limitations. They know the risks. They have policies in place to mitigate the risks. And that's why they're perfectly comfortable making these kinds of declarations. Because even if the neutrality statement falls through and a judge is going to go through your facts with a fine-tooth comb, you can back it up. And
Mhm.
what that says to your clients is, I know what I'm doing. What that says to the court is, I know what I'm doing. It becomes a problem where if I, as a judge, challenge you and you have no idea what you're talking about, that's the conversation that needs to happen. Frankly, it's the conversation that needed to happen after the pandemic when this all started. The problem is the legal profession has this weird dichotomy with innovation where everyone's all gung-ho about, modernizing as long as we have absolutely no idea what we're doing with it. I appreciate the enthusiasm, but there's so many risks that are not understood, that are not properly studied. We're only able to adapt now because we've seen people screw up bad enough that courts have had to make decisions on it.
Mhm.
You don't want to be one of those examples.
Right. Yeah. Yeah, no, I can definitely see some of those points. What I'll be interested to see is, and I don't even know if this would be possible, but like, is there an ATIP down the road to see, okay, this policy's existed for 6, 12 months, 18 months, whatever. Does the disclosure have any effect on approval rates? Or, for litigation purposes, approval maybe is not the right word, but, sending it back to overturning and sending back to IRCC. So that's something I would maybe want to keep an eye on. I don't know if you have any insight into that, but that would be my concern, right? Like, yes, it's everything you say makes sense, and in principle it makes sense. And yes, it seems like there's a bunch of really smart lawyers out there using the best tools and then being comfortable disclosing it. After 6, 12 months of those applications, what are their approval ratings like compared to their counterparts who don't use it? I don't know if anybody knows that yet, but it'll be interesting to find out.
Absolutely. And look, it's an interesting question that I've actually heard it a few times, but there is no answer right now. And even the accessibility of that information, there was an Ontario Court of Appeal case not long ago that the Attorney General has no influence or sway on what information a court is required to disclose. It comes down to the willingness of each court and their Chief Justice to make that kind of disclosure. But when it comes to the court's broader obligation to, again, this public trust in the institution, I think that goes a long way. I know for a fact that this kind of data is being tracked, but there's this question of, how does it change anything? Does it change anything? At least anecdotally, I think the answer is no so far. Because there's really only two ways you could use a generative AI in a legal document. You're either using it to summarize information or come up with information. If you're using it to summarize information, I mean, disclosure aside, it's really quite innocuous. You just check it, you make sure that what it says is right, and you move on. If you're using it to come up with legal arguments, ChatGPT does not have a law degree. It is not licensed to do that. Don't do that.
Yeah.
And that's going to get you in trouble whether or not you disclose it. Because if you say a case says something that it doesn't, the clerk or the judge is going to pick up on it if the other side doesn't, and they'll pick you apart over it. It doesn't matter if you disclosed.
Right. Yeah. No, super interesting. And I think we might need future conversations as this stuff evolves and kind of plays out. So before I took us on the longest tangent, do you want to maybe go back to talking about the second document that you were going to mention?
Yeah. The second document is more of a living document at this point, but it's the federal court's so far interim principles and guidelines on the court's own use of artificial intelligence. And that raised a lot of eyebrows when we released that last year because no other court in the country had a policy on using AI. And frankly, even though the Canadian Judicial Council just released a model set of guidelines on what that could look like, at least from what I've seen, there is still no other policy from any other court authorizing the use of artificial intelligence. And a lot of the principles between the court's own use policy and the policy on use by counsel, they seem quite similar, but they play out very differently. Because we're talking about, protecting the integrity of legal proceedings. That's one thing. It could shake public trust in the institution. It could affect judicial decision making. It could get you thrown in front of the disciplinary committee. But as bad as all of those things are, we already have a lot of mechanisms in place to deal with it. What happens if the court took a similar approach to the profession 2 years ago and started playing with generative tools and rolling everything out without any kind of check and balance, without a question of how do we do this safely, how do we do this responsibly, and in a way that respects people's constitutional rights? And that's the big distinction between the two. The court has to make sure that judicial independence and respecting the constitutional rights of litigants are paramount throughout those kinds of strategies. So integrating something like a human in the loop principle, absolute must. Because when you're considering not just generative cases, generative is, I think, relatively easy to deal with by courts. There's certain use cases that make sense and a lot of use cases that don't. But it's non-generative use cases, automated decision-making systems that blur that line a lot more. And the two examples I love using, which sound hilariously innocuous, are scheduling and case assignment. If you have a non-generative system that manages the court's scheduling of when a hearing is going to take place or a case management call, how do you know that the times that you're being given are giving you your best chance at success? It's a weird little question, but if you have a judge first thing in the morning, they might be a little warmer to you. They haven't had a very long day yet. If you're the guy at like 4:00 and you're the fourth judicial review of the day, you might have something to say. And if it were a human, if it were a registry officer making that kind of call, or you picked it yourself, sure, that's one thing. But you can't go ask a non-generative system why it keeps giving you the 4:00 slot. And that might end up looking like bias. It's not bias from a judge. That's the funny part. It's bias of the broader court institution. And because it's always been humans making these decisions one way or another, it's never come up. It raises weird questions like, could a registry, a court registry, as an institution be biased when the members of court aren't? Could they be biased against you as an individual? How is it determining what it's assigning you? And that goes the same with case assignment, determining which judge you're going to get. It could be a simple rules-based automation system. If you keep getting certain judges, or you see judges have certain trends and they keep getting more kinds of cases, does the assignment of the judge bias the decision or bias against you as counsel? If you know the way the system is shaken out, your kind of file is not the one that the judge usually takes. And there's some weird, I'll call it judge shopping analytics going on in the profession right now about, there are some immigration focused judges and some judges at the federal court that, they don't have an immigration background. They're being introduced to it for the first time when they're appointed. Does that affect your chances? We don't have any scientific information on that. But I bet you that if those decisions were being made by a non-human, they'd have very weird consequences if the answer was yes. And it's a weird, I'll call it artifact of the reality that even though none of the actual results may change between an AI system and a human making these decisions, that a human didn't make that decision. And it wasn't completely random. The registry officer drew your number and that's the judge and the time you get. You have no way of knowing. And that's the problem. You can't go to that registry officer and say, why did I get this?
Mm-hmm.
And it's this explainability gap where you can't just go ask a non-generative system or even a generative system. You gave me this response. Why did you give me this response? A registry officer could tell you. You might not like it, but they could tell you.
Right. I mean, it almost makes me think that there should therefore definitely be a limitation to what we're using generative AI for, right? Because the scheduling and the judge stuff that you're saying is super interesting. Do you really need generative AI to give somebody a court date, right? Could
Mm,
that not just be done with relatively straightforward automation? Hey, you want to book this type of case? Okay, well, the next available slot is X. Here's X. The next person logs in. Hey, I
mm.
want the same thing. Okay, the next slot is Y. Here's Y, right? And there's kind of like not much decision making other than what is the next one or when is the next judge available on this day sort of thing. So that it's super interesting. I mean, these are things that at least someone like me is not thinking about on a day to day. So it's super interesting to get to understand what's happening at the court level, behind the court level, right? But behind the scenes and stuff like that. I'd love to also talk a little bit, Daniel, about so far we've kind of covered a little bit of practice management, but more so related to the courts. You work with a lot of law firms that are trying to understand all this stuff, ask some of these interesting types of questions. Can you start by just telling us a little bit about how do you work with law firms? Like, what are law firms, generally speaking, looking for help with?
Well, it's funny because when I started doing this work at the court, there were a lot of these, fundamental, pie in the sky questions of, we have a policy on the court using AI, but like, how do we actually do that? And the assumption at the time was, well, we're a court, it's government managed. There are all these, institutional barriers that would be absolutely unique to us because we're a court. Not as true as you'd think. The reality is just that the legal profession generally and all of its systems and regulation and governance were never built with the semblance of change management background. And
Hmm.
that's what I started doing in my later time at the court, moving into private practice and working with, law firms, government departments, research centers to start asking the truly fundamental questions of, it doesn't really matter if you preferred ChatGPT 4.0 over, something like Llama, but what do you want to use it for? And would it be valuable? Something as basic as would it be valuable? And this is why I really liked your point on, do we need generative systems for these kind of things? I think the answer is no. And there's a lot of hype, unfortunately, around generative systems specifically because it's sleek, it's new, it's sexy, it's innovative, and to a lot of people, it just seems like black magic. But that doesn't mean it's always the best solution to every problem. It's new, it's shiny, and in a lot of cases, you can get a lot of value out of a generative system. But that doesn't mean it's always the best tool for the job. There's a big gap in I'll call it legal tech deployment between the early and mid 2000s to where we are now. And I don't think COVID helped with it, ironically, because we kind of forced the profession to make this shift very much against their will, quite begrudgingly. And now we're seeing a strong pull to go back from that. Courts are going back to a default of in-person hearings. Lawyers are trying to go back to, dealing with clients in person and getting everyone back into the office. And we're not really taking stock of the real lessons here. And the first question that has to be asked is, why are you doing this? If you want to use an AI system, great. Talk to someone who knows something about it, get a good idea of what you're dealing with. But it's not enough to just say we want to replace all of our associates with a Gen AI.
Hmm.
Maybe not. Maybe not. But there's a lot of risk associated with that. And not just risk associated with the actual uses, but the getting there part. And that's where I'm finding the biggest gap is not just at the institutional level with courts and government departments, but something as simple as a small scale law firm, like a mom and pop shop. The idea that you can just take something so ingrained in our society as the practice of law and the administration of law, which is a side that a lot of people miss. And you can skip all the work to, we're just going to log into our accounts on ChatGPT, or we're going to use Grok. And that's going to put together our documents and file our memos for us. Even if that's what you wanted the end result to be, there's so many steps in the change management process to get from we have no idea how to use tech or what tech to use and why to completely automated digital law firm, it's not as, I'll even call it sexy, as people might want to think. There are a
Hmm.
lot of really valuable use cases for not just generative AI, but AI overall, non-generative systems, automated decision-making systems. If you limit your focus to just AI, you're going to start getting into this hammer and nail situation. Everything is going to start looking like a nail. You could start addressing a lot of the problems in the way your law firm works by deploying AI everywhere. Except it's probably not going to work very well. A lot of things are going to go wrong. And when it does, you're going to have no idea how to fix it
Hmm.
because you don't have the capacity, you don't have the expertise, you don't have the infrastructure even. The easiest thing that people forget when they're considering deploying these kinds of systems is compute. Being able to run a model, if you want to just, use your chips on ChatGPT, that's great. And when you run out, it just stops giving responses. No court that I've ever seen is going to accept as an excuse that you need an extension on a deadline because your ChatGPT account ran out. Not good enough. And
Hmm.
even if you wanted to take a generative model like that and bring it in-house in your own little black box server, not as simple as you just download an app and start using it internally. The systems, the hardware, and the networking that you would need internally to responsibly and safely use that kind of technology in a way that is not just efficient and won't crash your system, but will also respect data privacy laws, best practices on data governance, and now Law Society applications is a lot more than that. You're going to need a whole team of people who live and breathe this stuff to even get started. And
Hmm.
those are the kinds of conversations I'm starting to have with law firms is we want X, which is great, but there are 29 steps between here and X. I'm going to start walking you through the first 5 and see where we go. And I'm finding that there's really only 2 ways it goes. Either they were really enthusiastic anyway, and they're willing to put in that effort and the investment to get the output that they wanted. There are a lot of groups that thought that this would be a great lark to go on, and we're just going to pay our OpenAI subscriptions and automate our law firm. And when they find out, they're like, geez, this is actually a lot of work. And like, we're going to have to staff up, buy a whole bunch of infrastructure, figure out how we're going to change our workflows. It's not worth it. That's perfectly valid. You're not wrong in doing that, but it's nowhere near as easy as you're just going to log on to another website and try a new thing.
Hmm.
It's easy to try out, but to deploy this in an impactful way that's responsible and is safe and frankly meaningful, there's so much work involved in getting this right, especially in these early stages for the industry. If you're not willing to put in that kind of work, stick to doing what you're doing. That's okay.
Hmm.
And if you're willing to, fantastic. Give it a shot. Be willing to make a mistake and be ready to fix it. You can't, there is no in between there.
Yeah, it's great advice, and I'm nodding my head because I see this almost every week, right? Like I do every demo to any law firm that's interested in using Visto, and I've had more than one where we'll do the demo, we'll show them the tools, and they'll be like, wait, why doesn't the AI just do everything for you? And I'm like, what do you mean do every? And they're like, well, can I just click a button and everything's done? Like effectively kind of saying that. And I'm like, well, maybe one day, but we're pretty far away from that. You're still going to have to keep your day job for a little bit. And if our AI could do that, our prices would have a few extra zeros at the end as well, right? So I think part of it is number one, asking the right questions, as you're saying. Number two is a little bit of patience because, hey, the technology is going to get better. But like you said, I think there's a lot more to it than most people realize. So the last question, Daniel, I kind of want to end on, and maybe it's a loaded question, but I think it'll be interesting to hear your take, is what should what are 2 or 3 key things that these law firms should really keep in mind or be asking if it's like you said, they're seeing this AI stuff or they're hearing about it, they understand the potential, but maybe they're thinking about taking that first step or they're thinking about talking to somebody like you. what are maybe two or three things that you would tell to them or ask them to think about as they're starting to think about how to modernize their law firm?
Look, it's a great question. The first point I have to say is be honest, guys. If you want to explore something as radically different from everything you've ever done, as not just digitizing your processes, but automation, artificial intelligence, these kinds of things that law firms were not traditionally built to do, hats off to you. Fantastic. Go for it. But you need to be honest about what your firm is capable of. And that's not an indictment on, all the work that you've done and all the great staff that you have. It's not as easy as, taking these big bold ideas and handing it off to some guy in IT and they'll come back in 6 months with a finished product. Like this is fundamental reshaping of your workflow, of your day-to-day life. And if you're not ready for that shift, also be honest about that resistance. If you don't think that you and your team are in a position where you can make this kind of investment in resources and in time to fundamentally restructure your support network, your infrastructure, your backbone, your workflows, even the way you deal with your clients day to day, that's okay. And if you're willing to make that jump and take the plunge and play this game seriously, that's great. But the second part of being honest is understanding what your limitations are. You might have the best IT staff in the legal profession. Hats off to your guys. But not all IT is made equal here. And this is something I see largely at larger law firms and at the institutional level. Some of the courts across Canada, not just at the federal court, but from BC to Newfoundland and everything in between, they all have dedicated IT teams. And they are not bad at what they do. As a matter of fact, with what they're given, they pull off a lot of miracles every single day. But they were trained and educated and work every day in very specific environments with very specific tools, and sometimes in a limited set of programming languages. It's not enough to take someone who's only ever been trained in Java and has worked in Java for as long as Java's been a thing and drop something like a generative model on them and say, hey, figure this out, have fun. You're going to lose him real quick. And we're starting to see that on the IT side of the law, where we're making all these kinds of fundamental and I would say borderline irresponsible shifts with groups that frankly have the resources and the capacity to pull this off. They're trying to force this kind of change without considering whether or not it's something that's actually in their wheelhouse. If you're going to be changing from one network of systems to a completely different network of systems, either your IT team and everyone who touches them has to retrain and reskill and take the time to responsibly figure that out, or you need to switch teams. But it's nowhere near as easy as dropping it on their lap.
Mm-hmm. Great advice. Or of course, just sign up for Visto, right? Out of the box, ready to go. Anyways, I had to plug it there. Daniel, this has been really great. Number one, I've taken an interest this year, especially in what's coming out of the federal court, and you've had such a big part in that. So your insight there was great. The work that you're doing with law firms, it's really interesting to hear what those big picture conversations are. So just want to thank you very much for coming on the show and sharing a lot of this knowledge and advice. If people do want to learn more about you or get in touch or, check out your profile or anything like that, where do you recommend that they go?
If you want to reach me directly, I live and breathe on LinkedIn, as I think half of this profession does. If you want to read more about my research and my academic work and life since the court, I would highly recommend checking out our artificial intelligence risk and regulation lab at AIRRlab.com. And there you'll find our research team, some of our publications, the research projects that we're working on right now, and some really cutting edge stuff as far as the academic side of this profession is concerned.
Awesome. And we will have links to both Daniel's LinkedIn profile as well as that website. And maybe even for reference to the first half of the show, I'll throw in those papers from the federal court as well if people are interested in giving them a read. I definitely read the first one multiple times, and it's short document, and it's, I think, actually well written. I'm not just saying that because you're here, Daniel. But yeah, so it's definitely worth a read if you're interested in this topic. So we'll include links to that in the description, whether you're watching on YouTube or listening on your favorite podcast platform. Daniel, thank you again for coming on the show. Really appreciate it.
Thank you very much, Josh. Happy to be here.